Welcome to The Explainer. You know, we're all about taking those super dense, complicated documents and turning them into clear, visual stories that actually make sense.
So if your only experience with the legal system is from TV shows, you probably picture a lot of chaos, right? Surprise witnesses, last-minute objections. Well, the reality is a whole lot more structured. It's like a journey with a very specific map. And today, we're going to walk you through that map, step by step, using the official rulebook that every civil case has to follow.
We've broken this whole journey down into 5 main stages. First, we'll look at how a lawsuit even gets started, then how you bring the other person into the loop. After that, we'll see how the court figures out what the actual fight is about. Then comes the evidence, and finally, the grand finale, the verdict. Sound good? Let's jump in. Okay, so first things first, where does a lawsuit even begin? Well, every single civil case, no matter how big or small, kicks off with one single crucial piece of paper. You can't just storm into a courthouse and start arguing. The whole thing has to start officially in writing.
And that official document is called a plaint. Think of it as the starting pistol for the entire race. It's basically the opening chapter of the whole story. The plaintiff, that's the person who is suing, lays out everything. Who they are, who they're suing, why they're suing, and most importantly, what they want the court to do about it.
And you have to get this first step right because the rules are super strict. As you can see, it has to be signed, it has to be verified, meaning someone has to swear the facts are true, and it has to be filed by the right person. Now, this isn't just a bunch of red tape. These rules are there for a reason. They're safeguards to make sure that from the very beginning, the lawsuit is serious business built on actual facts, not just emotions. You know, a lawsuit is never a one-way street. It's got to be a two-way conversation. So for it to be a fair fight, you have to officially bring the other side into the ring. You can't just sue someone in secret, and the court makes darn sure of that.
So how does that happen? With a document called a summons. And don't let the name fool you, this is not a polite invitation. It's a legal command. It's the court itself tapping the defendant on the shoulder and saying, hey, a lawsuit has been filed against you, and you are now legally required to show up and answer for it.
But here's where it gets really interesting. Not all summons are the same. Right from the get-go, the court makes a huge decision. It can issue a summons just to get everyone in a room and figure out the core points of the disagreement. Or it can issue a summons for final disposal, which basically tells the defendant you need to show up with all your evidence and witnesses ready for the entire trial to happen right then and there. That one decision totally changes the pace of the game.
All right, let's move on to the next phase. This is where a big, messy dispute starts to get focused and the court really starts drawing the battle lines. The legal fog is about to clear. Okay, so the defendant gets the summons. What's their next move? They file their own formal response, which is called a written statement. It's their side of the story. So now the court has 2 documents, the plaintiff's original plaint and the defendant's statement. The court then takes both of these, puts them side by side, and boils everything down to the core questions that have to be answered. In legal speak, they call these the issues. And you really can't overstate how important this step is. I mean, look at this quote from our source material. It says that most of the difficulty of a trial is already over once you frame the correct issues. This is what turns a sprawling he said, she said argument into a focused set of questions like, was the contract actually broken? Or was this person truly negligent? Get this right, and you're halfway home. The battle lines are drawn. Now it's time for both sides to put their cards on the table. This is the part where simple claims and accusations have to be backed up with actual proof. First up, the paper trail. We're talking contracts, emails, receipts, medical records, all that documentary evidence. And you know, sometimes these documents can tell a way more powerful and honest story than any person ever could. Now here's another thing that's totally different from the movies. You can't just pull out a surprise, aha, gotcha document in the middle of the trial. The whole system is designed for fairness. The rules demand that you submit pretty much all of your documents right at the beginning, along with a list. And why is that? Well, it's a brilliant way to stop people from cooking up fake evidence halfway through the case. All right, next up is the human element. This is where we hear from the people who saw something, heard something, or know something. This is where the facts get a human voice.
When a witness takes the stand, it's not some chaotic free-for-all. It's actually a very structured 3-step dance. First, the side that called the witness gets to ask questions. That's the examination in chief. Then the other side gets their turn to question the witness and poke holes in their story. That's cross-examination. And finally, the first side can ask a few more questions to clear up anything that got muddy. It's a meticulous process, all designed to test the truth from every possible angle.
So, the arguments have been made, all the evidence is in, and the witnesses have said their piece. The main event is over. We are now entering the final act, the verdict, and everything that comes after. Let's see how this all gets wrapped up.
The endgame follows a very clear path. It all starts with final arguments, where each side gives their closing pitch. Then the judge pronounces the judgment. This isn't just who won or lost, it's the detailed explanation of why. That judgment then gets formalized into something called a decree, which is the official binding order. And that decree kicks off the final step, execution, which is really just a legal term for the winning party actually getting what the court said they should get.
And here's a point that catches a lot of people by surprise. If you win your case, you can start acting on it pretty much immediately. Just because the other side says they're going to appeal doesn't automatically put everything on hold. The winner can move forward and enforce that court order unless and until a higher court specifically steps in and says, everybody freeze.
So there you have it. This whole journey from that first document to the final verdict is built on a framework of rules, all designed to create a clear, final result. But as we just saw with things like appeals and the challenges of actually enforcing a verdict, it leaves us with one final thing to think about. In the real, messy world of the law, is a single trial ever truly the end of the story?